The topic is of course the immediately concluded oral argument in the FCC Verizon case. How many people were at the oral argument? Show of hands. Okay, excellent. I'm not going to assume that everyone, if you're here, you probably know the basic background of the case, and so I won't waste our time talking about it too much. I'll just mention a couple of quick things by way of giving my suggestion to the panelists about what I'd like to hear, to the extent that I have any say in it. As those who were at the hearing may have noticed, in some ways, I think it's fair to say that there were kind of two significant classes of question. One set turning on the FCC's authority to promulgate these rules under Section 706, and the other set of questions turning on the the issue of common carriage and whether the open internet rules are an improper imposition of common carriage. I think there was seemed like a lot more agreement on the common carriage issue, and perhaps a lot more amorphous talk on the authority question. And so one of the things I'd love to hear the panel discuss in particular, although I think we'll all be inclined to talk about common carriage because it was such a significant part of the oral argument, don't forget the 706 issue. I think it's important to note that as everyone doesn't seem to have noticed, that the FCC is asserting a direct authority under Section 706, not ancillary authority. And so another issue that I'd love to hear the panel address is what the difference is, and why that matters, and whether they're more likely to be able to establish the direct authority to regulate in some fashion like the open internet rules than they would be to find ancillary authority as the basis for the open internet rules. Relatedly, I think a question that was touched on a little bit, but perhaps not as much as I would have liked in the oral argument, is even if they do have the authority, was there sufficient justification offered in the open internet order or put before the court to justify those rules as a proper execution of the authority given under 706, assuming that it exists. There actually was a fair amount of discussion on this, but a lot less kind of resolution, and especially for those of you on the panel who are intimately familiar with the order itself. Rob, I'm looking in your direction. To the extent that you can speak to this, the question, some of the questions that were raised but not entirely resolved in the oral argument about the extent to which the order actually, again, supports the basis for authority asserted under 706. I think that would be a great topic to discuss, and certainly one that I suspect we'll have some debate on. So let me just very briefly introduce the panel, although I will ask each of the panelists to sort of introduce themselves when they start their remarks in the form of a 1 or 2 sentence biography. I don't know enough of your history to be able to do that, but I can certainly say their names. Unless, I'll leave it up to Matt. Matt Brill from Latham & Watkins is our moderator, and Matt, I'll leave it up to you to determine the order and everything. I'll just introduce everyone from the end of the table. At the end of the table, we have Fred Campbell from CLIP at the Competitive Enterprise Institute. Next to him is Rob McDowell, former FCC commissioner and now at the Hudson Institute. Sherwin from Public Knowledge. Matt Brill, I already pointed to. Markham Erickson from Steptoe and Johnson. And Berin, Szoka from TechFreedom. And with that, I will turn it over to Matt. And when it comes time for question and answer, I will do the Bob Barker yet again.
Thanks, Jeff. So for those who didn't get a chance to attend the argument, without repeating too much of the overview Jeff provided, I'll give just a short synopsis of the very lengthy and I thought fascinating discussion before the court this morning, and then we'll allow the panelists to talk in depth about each of the legal issues and some of the policy issues that are out there. The argument started with Verizon's counsel, Helgi Walker, receiving a lot of questions on whether Section 706 of the 96 Telecom Act, which is actually codified outside of the Communications Act, whether that provides affirmative authority, direct authority for the Commission to regulate in the area of open internet, net neutrality. And had historically disclaimed direct authority to regulate under Section 706 in the 1990s when the FCC regulated DSL services, which at the time were a leading form of broadband internet access services. In that context, when the Bell companies were seeking regulatory relief from certain obligations applicable to broadband services, the FCC said at the time that Section 706 wasn't an independent grant of authority, but rather shaped how the FCC should exercise its authority possessed elsewhere under Title II for telecom carriers, under Title VI perhaps for cable operators. The FCC reversed course in the open internet order and now is directly relying on 706. And the early part of the argument with Helgi Walker was really centering on the extent to which 706A and 706B, which I'll let the panelists explain a little bit, whether those provide the requisite statutory authority for these rules. I'd say that Helgi made a point under a case called Brown and Williamson that if you look at the entire structure of this statute and you look at the context where you've had numerous open internet pieces of legislation introduced in Congress and not adopted, where this is a prominent national debate where Congress has not acted, that context and the structure of the overall act suggests that we shouldn't search out implicit grants of authority that might be buried in provisions like 706, but rather the Verizon argument is that there would have to be some more direct and clear statement of authority from Congress to justify these rules. We then moved to a lengthy discussion about even if there is positive authority in the statute for the FCC to regulate, whether the nature of open internet requirements, and in particular the fact that they require non-discriminatory treatment of edge providers and prohibit what would be considered discriminatory treatment of edge providers, whether that set of rules amounts to common carriage and runs afoul of the prohibition in the statute against treating information service providers as common carriers. And the key here is that the FCC, in a series of decisions, starting with the cable modem order and the wireline broadband order applicable to DSL and other telco services, and addressing also wireless broadband and broadband over power line, that series of decisions all held that broadband internet access is an information service and doesn't include a separate telecom service. And so the implication of that is the FCC is statutorily barred from imposing common carrier requirements on broadband providers or treating them as common carriers. And so one central question that I think received the most attention was whether by their nature the open internet rules amount to a prohibited form of common carriage. There was brief discussion based on a question from Judge Silberman about the First Amendment and whether treating Verizon as a conduit or common carrier is consistent with the First Amendment, or whether instead Verizon really is a speaker with editorial discretion that has protected rights under the First Amendment. But that was a very brief portion of the discussion. And what really didn't come up at all, which is quite notable and conspicuous, was the broad question of ancillary authority. The Comcast case, where the Commission had first attempted to enforce net neutrality principles against Comcast, was vacated on the ground that the FCC relied on ancillary authority but couldn't justify that exercise of jurisdiction. And despite that being the central issue in Comcast, and despite it occupying quite a portion of the Commission's brief, it really wasn't discussed in any detail at all at argument today. There wasn't a discussion of how Title II provisions or Title VI provisions that had been identified as the predicate for exercising ancillary jurisdiction, why those provisions do or do not create a sufficient nexus or confer sufficiently concrete responsibilities for the FCC to invoke ancillary authority. So with that overview, let me start with you, Rob, since you were on the Commission, know the order well. Like to ask you about your overall, and if you'll venture a prediction of where you think the court may be heading.
Thanks, Matt, and that's a very good summary, and many thanks to TechFreedom for putting this together today and for allowing me time to eat some lunch after we all ran up the hill from the Court of Appeals. First of all, to take a step back, part of my concern with the order to begin with was really exemplified well in that courtroom today. You had a courtroom that was packed, and it was packed full of mainly what? Lawyers, okay, trying to determine the fate of the internet. And that's not hyperbole to say that. You also had 3 judges who we originally thought, arguments might slop over to about an hour. They might slop over the bounds, the time limits just a little bit. For 2 hours struggling with a lot of technical issues. I wish I'd kept a tally of how many times the judges said, I'm confused, I don't understand that, I'm having trouble with this. Not just with legal arguments, but with factual and technical explanations as well as distinctions between a telecom service and an information service. So I found there was a moment there where I actually found the whole moment rather chilling, that unfortunately we've gone from a day where disputes were handled in a non-governmental multi-stakeholder forum with academics and engineers and user groups and civil society, to now judges trying to figure out where internet governance should go. This is not just a bootstrap. This is not just a big leap from the sort of microcosm, little issues at hand, the splitting hairs of 706A and B and 202 and things like that. Because should the FCC win this case, the FCC will be untethered to regulate the whole sphere that we're talking about. The FCC has never in the course of this, whether it was the Comcast BitTorrent case or whether it was this case, it has never put a fence around its jurisdiction. It can do whatever it wants in its own mind, so long as it says it is for broadband. Now, there may be those in the room and on the panel who think that's a great idea, because the FCC, with the right people, if the right political election turns out the right way in someone's mind, the FCC will do the right thing, and that the ends justify the means. But that's not how our system of government operates. Congress must delegate to administrative agencies specific authority here, and that's what has not happened. Section 706, and these arguments came almost too late, but underline the word almost, Section 706 is a deregulatory section of the Act. It talks about removing regulatory barriers. It does not talk about adding more rules. There is no law of economics or of bureaucratic physics that says if you add more rules, it's going to cause more infrastructure investment. That's what 706 is about. It mandates the FCC issuing a report on broadband deployment, and you could argue adoption, I guess, by implication. And it talks about removing barriers to entry into that market, the broadband market. Okay. It has never, up until it became convenient for the FCC to try to use it as a fig leaf for its ultra vires action, in this case, it has never been used for any other purpose. It's never been interpreted by the Commission or courts as meaning really anything else. And it was only really, I think, starting with the 2010 broadband report, where was it 2010? Yeah, 09 was too soon. So it's 2010 broadband report where the Commission sort of broke with that precedent, saying, no, actually, there's a whole lot more to 706, and we're now changing the interpretation that we've had since 1996. So over 14 years. So I think that's important to note. And Matt, you're absolutely right. And one of the things that did get lost, and maybe I should also start off by saying, none of us really knows where the court's going to go. Okay, so we can all, prognosticate and.
I did go up and ask after, and they
told me.
Oh,
great. Congrats. But you're not telling.
Not say.
Yeah. But if you want to pay him a handsome fee as a client, he'll tell you. No. So none of us really knows. And judges, those very smart, 3 very smart judges. They love to be academic. They love to kind of drill past the questions that are really immediately before them. There's a lot going on there. So what we also saw, though, was that 45 minutes expand into 2 hours. I was fearful because I had an interview at 11:50, so that's why you saw me bolt out of the courtroom. Sorry, I didn't mean to be rude. Hope I didn't step on anybody's toes. But literally ran up Capitol Hill to do a quick interview before this. So the gating question, which I wish had more airtime during those 2 hours, was, does the Commission either have direct or ancillary authority to do what it did? That is what the legal basis was for my dissent. Now, that doesn't mean the court is skipping over that and assuming the commission does have that authority. It wasn't completely skipped over at all. They went off on all sorts of tangents because they're curious. Judges are curious, and they wanted to explore different rooms in this sort of mansion of possible legal arguments. But I do wish there had been more time on that gating question. Now, in the shadow of the Comcast decision from April of 2010, and other decisions too, I don't think this court and those judges in particular, those specific judges, are going to say the commission had the authority to do what it did. I also don't think it's going to blue pencil, as the term was used, the order. In other words, find some parts of it or stand or not. Now, what it may do is to say you didn't get it right, you didn't convince us, go back to the drawing board, which is kind of what it did in the first Comcast decision, or the Comcast decision. So that's entirely possible. But anyway, that's my not so quick summary. Sorry.
No, that's terrific. So let me ask you, Sherwin. We'll get into the question whether these rules are a prohibited form of common carriage. But before we do that, start where the panel started and talk about the affirmative authority that Rob mentioned. What, as a supporter of the order, what do you think is the Commission's strongest argument for statutory authority, and how do you think the panel's reaction, and what does it tell us about the court's thinking on this core threshold question of statutory authority?
I mean, I don't want to try and, again, prognosticate, right? I suppose being one of the parties in the suit, I don't want to try and guess as to where the court might be on this. I mean, I do think that the Commission does have a strong basis for authority, for direct authority in Section 706. Despite the fact that, maybe it was at the time that it was implemented was considered to be more deregulatory than what was the status quo at the time. It doesn't mean that is sort of its ultimate goal is complete deregulation. The trend in which it exists is not its text. Its text says that the Commission has authority to ensure the adoption of advanced communication services, and I think that the Commission makes a very strong case that this is exactly what we need, what this does, what this order does.
Fred, let me bring you into that debate. I mean, I heard Judge Silberman ask whether 706 would provide authority in the event that the Commission had asserted and shown market power. What he seemed to be suggesting was that if there was a true bottleneck with record support demonstrating that broadband providers like Verizon don't face effective competition, consumers can't switch, might not have just potential barriers to switching, but can't switch. He asked Verizon's counsel if she would concede that in that event, 706 might authorize regulation in this area, and she initially said yes, I think regretted it and spent the rest of her time trying to back away from it, and on rebuttal formally tried to renounce that concession. But help us understand, what is the relevance of the market power question? Does it really affect whether the Commission has authority, or does it affect the reasonableness of using that authority? How do you see that issue?
Yeah, so I'll give you some thoughts without any predictions for all the reasons others have mentioned. I think it starts with, backing up to the ancillary jurisdiction question. After the Supreme Court, I believe it was, ruled in the Tower case that there really is no separate jurisdictional question apart from Chevron, it at least raises the question as to whether the traditional notion of FCC ancillary jurisdiction even applies. So then the question would become, let's just hypothetically assume that they didn't ask a lot of questions about that because perhaps, and I'm not making this as a prediction, that's not really what they consider the relevant inquiry. And in the second case that I think relates to this, and I wrote a blog post to this effect immediately after it came out, and so now I feel better about myself, but it is the Szoka case on digital roaming where, Judge Tatel kind of laid out his view, the court's view, it was written by him, of what common carrier means. And the reason I'm raising that is, in that order, they found a specific hook, if you will, under the old ancillary jurisdiction rubric. You had to find a specific hook in Title III on which the FCC could sort of hang its hat. And it may be that really what we thought of as ancillary jurisdiction becomes essentially arguably the same analysis, but in a different, with a different set of labels, which is, which gets us to 706. They may be thinking, look, there is no ancillary jurisdiction per se. The question under the Supreme Court's articulation now of the Chevron doctrine is, is there an ambiguous statute that might cover this? And I think that's where it seemed that the judges were focused on 706 at this point. And so they may be thinking, okay, so that's where I have to start. Is there, does that statute, yes, it's ambiguous, assuming the fact that it's not codified doesn't undermine it as policy. Then, I've passed Chevron 1, and then you get to Chevron 2, which is, okay, did what they do, is it arbitrary and capricious? This is a long way of saying, one of the thoughts that occurred to me after reading the Supreme Court's opinion on the Tower case was the sort of arbitrary and capricious standard under Chevron 2 may be more important going forward than the role it's potentially played recently in the last, however many years when Chevron 1 seemed to be most of the argument. If Chevron 1 standard is somehow easier now under the Supreme Court case, then you have to wonder if there'll be a lot more focus on, does the rationale fit? Do the means fit the ends? Now, I'm speculating a lot here, and I'm not an appellate lawyer, but that's just how I read those couple of cases, and I think you can look at some of the questions they asked that potentially support some of that. Of course, I have no idea what they're going to do. So I didn't address, by the way, whether I think it's supported under that, and I can, or you can go to someone else and I can address it later. I do have some thoughts. But,
well, go ahead.
Well, some of the questions asked by both Judges Tatel and Silverman seem to me to be getting at this question, which was something I've also blogged about that's potentially troublesome about the FCC's justification in its order, which is that the three grounds for concern articulated in the order and mentioned by the General Counsel today, Mr. Lev, all would be, I think, accurately characterized as traditional market power issues by traditional, under sort of antitrust review and the like. And yet the order says those are our concerns, but then expressed says we don't have to worry about market power. And I think, under an arbitrary and capricious standard, I think there's a potential to say there's a disconnect there. And I think that was Judge Silverman's questions about, well, what are the facts here? Because, if your grounds for concern are all fall under a lens that, we the court traditionally viewed as a market power question, but you say you're not relying on market power, then what is the other rationale? And that goes to what former Commissioner McDowell just said, which is potentially you're completely unbounded. And I think the judges seem to be in their questions struggling with that. I don't know how they'll come out.
So, Markham, let me ask you also about the affirmative authority. As Fred mentioned, the data roaming case, that case did find that Section 303B, a provision of Title II that applies to wireless carriers, did provide direct statutory authority for the roaming requirement. And let's put that to one side and focus on the fixed providers, which can't be regulated under Title III. It did seem like 706 was, in the views of the panel, probably the best hook that the Commission had available. Two questions for you. One is, how does a provision that directs the FCC to encourage broadband deployment by removing barriers, essentially taking deregulatory action, justify net neutrality regulations, which Verizon characterized as a sort of a triple bank shot away, and to the extent that Judge Silverman is suggesting that it would be authority in the event of a market power finding, is he right? Does it require market power before the Commission can invoke that type of authority to take action of this sort?
So, thank you, Matt. And thank you, Berin, and for TechFreedom organizing this and for having me be part of this. And
the International Center for Law and Economics.
And the International Center for Law and Economics. I really do appreciate being here. And to just briefly echo what Sherwin said, I'm at a disadvantage in that our firm represents the interveners. So I don't think it'd be appropriate for me to talk about what people said or should have said or the merits of the individual arguments in the context of the oral arguments today, but to talk about the pleadings themselves and the order. And to reference just one thing Commissioner McDowell said, which I think is, he knows this better than anybody, this issue brings a lot of passion. that most telecom issues don't. And there is an article in today's Wall Street Journal, the front page on B1, where John Malone said the reason he is seeking consolidation in the cable industry is to get more market power to charge edge providers, and that he said Reed Hastings should begin building into his business model that he's going to pay me. And I think that the passion that John Malone has in that statement is, I think, equally, there's some passion for people that don't want to see that world. And so there is passion, I think, on all sides, consumers, ISPs, edge providers, in the future of how this marketplace develops, which bleeds into the legal issues, certainly. But, you know, I think in the Comcast case, when the Comcast order was struck down by the D.C. Circuit, the D.C. Circuit said that 706 arguably was an affirmative grant of authority, 706A, to the FCC, but noted that they had historically not taken that position. And so in the order, the FCC said that they are now taking the position that 706 is a direct grant of authority. And I think just on the exegesis of the statute, it says 706A, that the Commission may adopt measures that promote competition in the local telecommunications market or other regulating methods that remove barriers to infrastructure investment. And the FCC's interpretation is that means they can develop regulations if they find that they would remove barriers. But I think the strong, an equally strong argument at least, and it wasn't focused on as much in some of the pleadings, is 706B, which the Comcast court didn't get at, but the FCC really highlights that in their pleadings. And the FCC it's not a may. The FCC says, the 706B says, if the FCC finds that after an inquiry that advanced telecommunications services are not being deployed to all Americans in a reasonable, timely fashion, the Commission shall, it doesn't give the Commission any leeway in that, right? The Commission shall take immediate action to accelerate deployment of such capability by removing barriers to infrastructure investment and by promoting competition in the telecommunications market. So while 706A, I think the way to read these together, is permissive, that the Commission may take action, 706B says if the Commission finds that these services are not being deployed, which the Commission found, the Commission shall take immediate action to remedy that situation. So I think that on the face of the language, and one may fault Congress for not being precise, Congress gave the Commission a direct mandate there that certainly the Commission can hang regulations under, even regulations that are that get at the breadth of internet access, as Helgi gets to. Then the question is, if you agree that there is, the question that came from Matt is, if you agree that there is statutory authority, what part of the equation does market power fit into? And this is something that hasn't been totally resolved, because in the 96 Act, Congress said that in their non-discrimination principles that they were adopting in the Cable Act and other places, that they were not meaning to provide a replication of the antitrust laws. So if market power isn't a traditional antitrust theory, if you don't have to satisfy what the DOJ would have to satisfy, then what does market power mean? And it's something the courts really haven't resolved in the D.C. Circuit's case. In the Second Circuit's case in Time Warner, that had to deal with the cable carriage regulations. The Second Circuit says that the FCC needs to find some evidence of market power. What that means, whether it's traditional antitrust market power or some other form of market power, I don't think has been resolved. I don't think it would be that difficult for the FCC to show that there's some market power. What the other rationale is in the order is the FCC really said that that it's the terminating access monopoly that animated the rules, and which obviated the need for a market power, traditional market power analysis. And that is the issue. That is one of the issues before the court.
Well, Commissioner, let me get your take on the market power issue, because there was a moment in the argument where Judge Silverman chided the FCC's general counsel because the Commission's order, he said, was arguably deceptive in the sense that it mentions sort of indicia of market power, market share data, lack of choice, but goes on to say that consumers may have impediments and may have difficulties, and really doesn't, in the end, rely on a finding of market power. And the suggestion seemed to be that the Commission is having it a bit both ways, relying on sort of a flavor of market power without having to defend it. And Commissioner, I know that factored into your dissent, but what do you think the import of that exchange was, and how significant do you think those market power issues will turn out to be?
Well, I think that was mainly Judge Silverman, and sort of antitrust law is one of his first loves, so it's important for people to understand that context. So he's naturally going to look at this from that type of, through that type of lens. And he's absolutely right, and there was no market study done. The evidence, the actual factual evidence in the record is extremely thin, in fact, almost entirely non-existent. That was one of the reasons for my dissent as well. So, had the FCC been more methodical and observed process and done a bona fide peer-reviewed market analysis, then you can start talking about legal questions as to whether what kind of jurisdiction it has. But it didn't do any of that. If they're not going to address the gating issue of whether the commission had the authority to do what it did, then maybe for him this is something, some other nail to hang his hat on. He talked about a lot of other things though too. So, and you can't tell with judges. Again, sometimes they are. It was a great. Obviously, they were very interested in the topic. That's why it went so long. They enjoy their jobs, you could tell. So, especially in a day like today. So they're there to think sort of academically as well as beyond, as well as what's before them, but well beyond what's before them. But the idea of what facts and what evidence weren't just Judge Silverman, Judge Tatel, and I think also Judge Rogers mentioned it at one point as well. So, facts are important, and they do matter, and we shall see whether or not the court actually goes there, just the way we'll see if it actually gets to the First Amendment question. I don't think it will.
Matt, can I kind of address because I think it's an interesting point. I think the judge is focused on hypotheticals a lot for a reason, which is going to your point about 706B. And by the way, I'm not very passionate about these issues, in part because I don't think legal analysis is aided by passion. I think it's aided more by dispassion. In other words, I'm trying to just stick to what the legal analysis might be. It seems to me that if it mandates you need to promote competition, hypothetically assuming the court says, yes, that's enough to get jurisdiction to do something. And then you get into what is the something they can do, which you might decide is ambiguous, or you may, and then do an analysis of Chevron 2 on that, or you may say it's actually not ambiguous, that there are certain some things you don't have authority to do. And that's where I think the common carrier part comes in. So, for example, I'm just speculating here and going off what I thought some of the interaction between the judges were. But the reason for traditional common carrier regulation was not to promote competition. It was put in place because there was zero competition or choice. There was a monopoly. So the point of common carrier regulation 201 and 202 was to help the market work in the absence of any competition at all. So one way the judges could go is to say, yeah, I'm saying hypothetically, if they decide there's jurisdiction, yes, you have jurisdiction to do something to promote competition. But Congress has said that something can't include common carrier regulation, which gets you to Judge Tatel's opinion in the roaming case, which I think is why it was talked about so much. There, Judge Tatel basically said just that. You cannot impose common carrier regulation, which leaves the question is what is and what is not common carrier regulation, and that's why I think you heard both judges as focusing on the next hypothetical, which is blocking different than non-discrimination? Because what the FCC did in their order that I thought was very aggressive is they took the word unreasonable and they sort of cabined it in the non-discrimination provision of net neutrality regulations that they adopted and said that just applies to reasonable network management. Now, why is that aggressive? Under traditional common carrier regulation, put in place when there wasn't a choice of 2 in 70% of the markets, there was a choice of 1 in 100% of the markets. Under 201 and 202, 70 years of precedent says unreasonable includes reasonable price discrimination. And you can go find the cases that approve tariffs with volume discounts and the like. And arguably, the FCC order, and I think the judges struggle with what it means, as I think we all do. Arguably, the judges were concerned, well, if your order prohibits that, you've done under what was originally called ancillary jurisdiction, something your primary jurisdiction doesn't even allow. So I think going to your point, even if they have jurisdiction to do something, That was my disconnect point. I think there was a disconnect between the perceived harms and the remedy. I think they've got some real issues on the sort of next step in the analysis that could be troubling to the judges, and who knows what they do with it.
So there are a lot of pieces to this common carrier argument. Let's try to unpack them a little bit. What Judge Tatel wrote in the data roaming case was even though there was a duty of wireless providers to enter into roaming agreements, a compulsion to serve, that in the end, in his view, and the panel's unanimous decision, was not common carriage because it was not an indiscriminate offering on standardized terms, but rather there was flexibility on the part of a Verizon Wireless to enter into differential terms with different roaming partners, and that flexibility, the court held, made it a form of private carriage, not common carriage. And what Verizon argued in this case is that the obligation to carry the traffic of all edge providers without charge, without discrimination, is the essence of common carriage. And so, Markham, you're on the other side of that debate. Help us understand the argument of why it isn't common carriage and why it's a permissible form of regulation.
Well, I think the FCC does have to show that there's flexibility and that to show that it's not common carriage. And I think the reason Verizon in its briefing focused on the blocking and the zero rate, the inability to charge anything, was because if they start going into the issues you talked about, which is issues of charging different parties different amounts for various reasons, I think the order itself does provide that kind of flexibility. So one is the order creates a safety valve for specialized services to say that there can be something that an ISP does that's short of broadband internet access. It's not delivering traffic to any and all endpoints, substantially all endpoints on the internet. It could be hospitals or something like that, and that the rules were not going to cover those. Secondly, they talked about unreasonable discrimination, and my reading of the order actually isn't limited to unreasonable discrimination. It's only in the context of network management. The way I read the order is that network management is something that has to be applied, but that unreasonable discrimination is not cabined by network management. So, for instance, there could be issues of type-based discrimination based on reasonable distinctions between types of traffic that I don't think the order would get to. So I do think that there is that flexibility. The FCC also makes a point of saying that there's no relationship with the edge providers, at least in the market they analyzed at the time that the rules were being adopted, that the ISP's customer are their end users. The edge customers have a separate relationship with ISPs, and what they were really trying to do in the briefing, I think, is to say no one's getting a free ride. Everybody is paying into this ecosystem to have their traffic delivered and terminated.
So I do think, yeah, please.
Half an hour without being able to talk is almost too much for me to bear. So I have to say this, and everyone who's been to events here will know that that's true. But I have to say this is exactly. This is exactly where I think that the entire case is going to hinge. As Jeff said at the outset here, logically speaking, the first question you ask, of course, is there statutory authority? And that could be ancillary, as the Commission does assert here, or it could be the direct claim of authority that they assert under 706 and spend almost all of their brief defending. But frankly, I don't think that question matters. I think it's very likely that you could see a decision here that simply bypasses that question, because the court, I think it was very clear today that Judge Silverman and probably Judge Tatel seem to think that at least the anti-discrimination rule imposes common carriage in violation of the Communications Act for the reasons we've just been discussing. If that's true, the only question at that point becomes the question about blue lining. In other words, if the order is separable, then yes, the Commission has to go and examine whether the court has to examine whether the Commission has authority under some provision for the transparency and anti-blocking rules. If, however, the court decides that the order is not separable, which is very strongly where they hinted they were going today, the court doesn't even have to make that determination. All it has to say is there is at least one portion here that constitutes an imposition of common carriage, which is the non-discrimination rule. They throw that out. They don't even have to reach a decision on statutory authority or on anything, or on constitutional issues or anything else.
Let me ask you a follow-up about that. Judge Tatel spent a lot of time trying to parse the distinction between the ban on discrimination on the one hand and the no blocking rule on the other. And there was a lot of confusion in the dialogue with counsel for each party, and Judge Tatel really seemed to want to understand whether there was a way to blue pencil the decision, as it was put, by striking the non-discrimination rules as a prohibited form of common carriage, but then preserving the no blocking rule as permissible under the theory of the Roman case, which is that although you can't block, it's not, and there's a compulsion to serve, it's not a common carrier compulsion to serve because it can be exercised flexibly. So Berin, is that right? I mean, should the commission be upheld on no blocking on the theory that it's no longer common carriage once you're free to discriminate?
Well, I think so. I think there are two defenses that they make. The first is in the order in paragraph 79, they say that the relevant class of customers here is the end subscribers, broadband subscribers, and they specifically argue that the edge providers are not a relevant category. So as far as they're concerned, at the outset, that doesn't apply. Now, I think that's clearly wrong. In the data roaming order, where the commission mandated that one carrier provide data roaming service to the customers of another carrier, that was clearly held to be potentially common carriage, even though the mandated issue was that one carrier has to provide a service actually through another carrier, ultimately to end users. So I think that distinction is clearly not right. And there was a long discussion today about the analogy to Midwest Video, where I think Verizon very rightly said that the broadcasters there were in precisely the same situation as edge providers here. So then that brings us to the question that you ask, which is, does the FCC remove that problem by saying, well, we're not mandating that you have to carry someone's signal, or we're not removing all room for commercial negotiation, which is what Tatel's decision turned on in the data roaming order. We're allowing that room because as long as you don't block, you can charge a provider for premium service. The short answer is, based on the questions asked today, that's certainly not going to fly for Judge Silverman, and I think Judge Tatel was very skeptical of that argument. At the end of the day, what he seemed to articulate, and this is what he spent so much time trying to draw out from lawyers on both sides, was where would room for commercially reasonable negotiation lie? And at the end of the day, what Verizon conceded, if they conceded anything, was that a pure no blocking rule that simply said that a carrier cannot block content, but allowed a carrier to negotiate for reasonable service, that might constitute a sufficiently private degree of carriage that it wouldn't violate the prohibition on imposing common carrier status. But even there, that still doesn't mean that Verizon loses. Verizon still has other arguments, and they still certainly point back to the market power analysis.
Well, and let me talk a little bit more about the specialized services out that Markham mentioned. And Sherwin, I'd like to get your view. Public knowledge, I think, has been concerned that the FCC's decision not to regulate specialized services could be a mechanism to end-run open internet requirements, because if a provider is told there's no pay for priority, that's discriminatory, it's contrary to open internet, unless you just call it a specialized service, I presume that that's something public knowledge is concerned about. At the same time, I don't really want to drive a wedge with your counsel, but I kind of do. Counsel for Interveners suggested today that Verizon could have a pay-for-priority relationship with Google as long as it was carried over FiOS. Now, that caused some confusion about whether there was FiOS Internet or FiOS Video.
There was some,
but let's assume we're talking about a specialized service that would be a dedicated IP, non-video channel. In the view of public knowledge, is it okay for a broadband ISP to strike a deal with Google that's a prioritized arrangement just by labeling it specialized service?
No, I mean, I don't think that just changing the name to specialized services is what gets you sort of around anti-discrimination.
So what does?
So the idea behind that is to make sure that you can have a system. For example, I think somebody who carries both cable television and broadband over their IP, internet protocol lines, they have the ability to just to divvy that's the breadth of that pipe as they please. And we don't want to necessarily make sure that, we eliminate or we're going to require that the whole of that pipe be devoted to internet broadband access services. So part of the idea is to make sure that there's a space for something that might be akin to, I think this is where some of the confusion came in, where people are talking about over-the-top providers or things like that. I think it's a difficult question, and one that you actually want to look at the facts of what is being proposed as a specialized service before you make a straight-up determination as to whether or not you're just going to blanketly, obviously you don't want this exception to swallow the rule.
Let me get to invoke the moderator's privilege that the judges invoked, which is to ask hypotheticals. And let's assume that there's ample bandwidth available and that the offering of a specialized service isn't going to starve the public broadband internet access service of sufficient bandwidth for robust usage. So let's assume that, and then let's assume that Verizon wants to enter into a specialized services arrangement with Netflix to provide faster delivery of Netflix movies for a fee to Netflix, not to the end user, and that isn't starving the otherwise available broadband channel of capacity. Is that a reasonable or an unreasonable arrangement under these rules?
I think one of the primary issues is making sure that you're not degrading somebody else's service. And in the universe that we've been seeing so far, it basically seems, because people keep crying congestion, that prioritizing one service is going to degrade another. In a universe where that would never happen, I think that there's potentially room for specialized services.
So, and Markham, let me ask you another piece of that. I mean, your colleague stated that an example of a specialized service would be offering a prioritized high bandwidth service to hospitals, and it seemed the implication was it's not anti-competitive, it's to benefit medicine, so it's okay. What makes that okay and more commercial pay for priority arrangements less reasonable, where if we assume that they're not degrading the otherwise available bandwidth? And where's the line?
Yeah, so I have two-part answer. One is what the order states, where I think that's what we most, as lawyers, probably care about. And the second, the policy underpinnings behind the specialized services category. The order says that it's regulating broadband internet access, which it defines as a service that gets one to all or substantially all endpoints on the internet. So that's what most people consider their internet access service now. You can go wherever you want. So a specialized service under the order is contemplated as something that is not that. Meaning, if it's not getting you to all or substantially all endpoints on the internet, but it's delivered over IP, say it's just for hospital, it's a connection that gets you to a hospital, and it's clear, they're not trying to, the ISP is not mislabeling this as broadband internet access. It's just to get to one provider, an edge provider, a video provider, a hospital, that would not be broadband internet access service, and so it's not covered by the order. Where the line is between all and substantially all endpoints on the internet and something less than that, where that is, 100 websites, 1,000 websites, the order doesn't define that, and they give themselves flexibility to look at that on a case-by-case basis, but they put in a couple of considerations. One is that if this is really a ruse to eliminate the broadband internet access service and replace it with these specialized services, then the FCC is going to say, well, you're really just trying to undermine your broadband internet access service. So that's one of the qualifications. The policy underpinning is your hypothetical, as I think it speaks to. The FCC they want to incentivize robust pipes. But if you have more capacity than you have to deliver internet traffic without congestion, then why should the ISP be punished by having all that capacity by not being able to have separate commercial arrangements to monetize, relationships with hospitals and other things? So they wanted to reward the ISP for building that capacity by allowing these different kind of arrangements. That's the policy underpinning. But as a matter of the order, where the line is not entirely clear.
So, Berin, I had a question for you. Well, if you want to follow up on specialized service, do that first.
I just find that fascinating. So the goal of the FCC, Markham, was to encourage the build-out by allowing companies to monetize the pipes that they're building, and you say they can do that for these certain specialized services, but they can't charge Netflix for delivering faster traffic.
The goal is not to punish the broadband. If you have extra capacity, and there's plenty of capacity for broadband internet access service, is the commission, is an ISP able to use the other parts of the pipe? And what the commission says, if it's not broadband internet access service, you can, and that's what we would call a specialized service. So in your example, if an edge provider has a relationship with an ISP to provide that specialized service, that would be allowed under the rules.
Okay, so what exactly are you afraid of then? What is it here that requires the rules? Because this is the very question the court kept coming back to today.
What the order says, what they're worried about, is that if you just allowed that without the rules, the ISP would not be incentivized to build out, because they would create artificial scarcity to say, look, in order to have the kind of relationship with our customers that you need, you'll have to buy this super high bandwidth part of the pipe, and they're not going to actually make the broadband internet access service robust enough for an edge provider to interact with their consumers the way they do today. So they were trying to balance that. I'm just speaking to how the order tries to balance that. But it's not an entirely bright line in terms of where specialized service and broadband internet access service begin.
Let me get one more question to Rob, and then make sure we take some questions, because I know the commissioner has some constraints in his time. But one question I wanted to ask you about was the interplay between this whole common carrier debate and the First Amendment, because Judge Silverman seemed to recognize, as he was questioning the FCC's answer to why this doesn't violate the First Amendment is that Verizon is acting as a conduit. It's not a speaker. And Judge Silverman pointed out, I think, that, well, doesn't that mean you're a common carrier? And you're conceding that this is a prohibited form of common carrier. So does the FCC's defense to the First Amendment argument compel them to concede the argument on the common carrier issue, or is there some sort of conduit argument that they have that doesn't make it common carrier?
I think they conceded many times, whether they wanted to or not, that this is de facto common carriage regulation. I mean, it walks like a duck, it quacks like a duck, and all that stuff. It's laying eggs all over the place. So I think clearly that was part of what he was trying to get at. I don't think it has to be a gating issue. He's not going to necessarily, this is unconstitutional under the First Amendment. I don't think they'll address that, but it could be part of his thinking. I think it's very observant of you.
Oh, just to that, I don't think that you necessarily have to concede that you're a common carrier just by not being a speaker. Verizon itself takes advantage of the fact that it falls under Section 230, which absolves it from any implications, any liability for the speech of its customers. And it also, many types of internet services, which are not common carriers, take advantage of the safe harbors under Section 512, which do the exact same thing. They draw that distinction between who is and who is not a speaker without forcing them to be considered common carriers.
I have to just jump in here and just point you to our amicus brief and suggest that's not an accurate explanation of how 230 works. That is not the basis for 230's safe harbor. You can be a speaker. The key issue in Section 230 is simply whether the traditional doctrine of publisher liability applies, and Congress simply said, no, it does not, so that online intermediaries, regardless of their status as speakers, are not to be treated as publishers of information as they would have been under common law publisher liability. So there's nothing inconsistent about Verizon or anyone else claiming a Section 230 safe harbor immunity for user content and saying that they have speaker rights, which has been recognized under doctrine for 20 years. This is not some crazy argument that Verizon invented to try to take over the internet.
And yet, the First Amendment argument doesn't seem to be taking a lot of hold in a lot of these cases.
And the reason it didn't take a lot of time today is because it seems so clear the Commission's going to lose on common carriage grounds that it seems unlikely that the Court's actually going to get to the First Amendment issues.
And if we are going to talk about policy, I think it's interesting to see whether or not Verizon is willing to make the argument in public that it exercises a First Amendment right to alter, adjust, or censor, or block its users' speech.
Berin, can I jump in here? I actually think what I said earlier about being dispassionate, I do think the way the judges' questions were going, the way they looked at this case, they see it as largely a set of economic issues. And I think it is. I think this is a set of economic issues that have been pending at the FCC under various guises in various different categories of services for decades. The sad thing to me about this whole deal is that the effort to build sort of a grassroots movement around this, I think we lost sight of and focus on some of the more important issues out there. In other words, an economic issue, not saying it's not an important economic issue, but an economic issue by itself, in and of itself, became equated with internet freedom. And so it all became about this. And Washington spent a decade or more, and we're still doing it, talking about it. And in the meantime, not worrying at all about any of the other potential issues like First Amendment, Fourth Amendment, and the like. And all of a sudden, lo and behold, NSA, what's going on here? Well, you know, bad things usually happen when you're not paying any attention to them. This is all of a lot of background for a segue to say, I don't think the speaker issue is even relevant to the First Amendment question, in my view. If you look at the history of the printing press, which is what gave rise to this whole press clause thing, the early printing presses were all wholesalers. They weren't integrated the way a newspaper is today, where today, and that didn't happen until the advent of the steam press, i.e., you know, electrical power and the like, or steam power in that case. But there were no daily newspapers back in the day, especially when the events giving rise to the adoption of the First Amendment happened. There was no daily newspaper as such as we know it today when the First Amendment was written. It didn't happen until the 1830s, because they didn't have the ability with a hand press to pump out a bunch of copies and deliver them every morning to someone. Along comes the 20th century, and through a whole series of cases based on existing conditions, everyone thinks of the press as a fully integrated, vertically integrated thing, where you have somebody who owns what is now filling an entire building, big, expensive printing press machinery, and they hire the reporter, so they control everything all at once. The irony here is, the fundamental argument that the First Amendment doesn't apply goes like this. You are not a vertically integrated industry, which makes you not a speaker. But, hey, if you were a vertically integrated industry, you'd have First Amendment protection. But hey, the point of our rules is to prevent you from becoming a vertically integrated industry. The logic here is clear. The issue, again, is under the First Amendment, how did the British Crown, how did the French government, what did they do to crack down on all the heretical thoughts out there in the 16th, 17th, 18th centuries? They regulated the apparatus, the printing press, that was providing wholesale services. So this distinction between who the end user is and the wholesale thing, meaningless. This idea that because you're not vertically integrated, we can enact rules that prevent you becoming vertically integrated. What?
So let me just add a brief coda to that. Number one, that concept is what Chris Yu calls architectural censorship, and it's something that is played out in many countries very clearly, where things like media ownership regulations, for example in Argentina, have been used for clearly political ends. It's clearly possible to control.
To tie it all up.
Talking about the theory of possibly ending up like Argentina. I mean, I think it's interesting you're talking about this in terms of vertical integration, because I think that actually brings us to the economic question at stake, which is, when we look at the question of market power, which if we were talking about this as an economic issue, I don't see why definitions of market power, discussions of competition, have to be entirely subsumed within an antitrust framework. I mean, I think that it's clear that there are interests at stake that are not purely antitrust, and that's why we have concerns with competition, with the fact that you have a bottleneck and a terminating access monopoly without showing sort of a geographic market power.
All right, let me just pause right here, just because we have some constraints on Rob's time, and I want to make sure we have at least a little time for questions, particularly for the commissioner before he's got to go. Right here.
Definition of reasonable and timely, if that's what the state of play is with that. If there's a standard definition of what you think about the definition of whether broadband's being built out in reasonable and timely fashion, if you could just kind of flesh out the definition of that a little bit.
Well, I mean, I will say, one question we're just hearing from the panelists is when we use a phrase market power, it can mean one of two things. It can mean market power from a strict antitrust standpoint, which is the power to raise prices by a certain percentage without a competitive response, or it can mean something broader and more public interest-y. From an FCC perspective, it can mean insufficient competition. I think your question also brings in whether deployment is deemed reasonable, and Rob, maybe you have thoughts on that because you dissented to the conclusions about reasonableness.
So yeah, no, excellent point to raise. So not only did the commission have to throw out its many years of thinking to conjure a new meaning for Section 706 in the 706 report of 2010, but it also had to contort market data, or its view of market data, to say that in 2003 that 15% of Americans had access to a broadband provider. By 2009, end of 2009, 95% of Americans had access to at least one broadband provider, and speeds were going up, and there were more providers and more infrastructure being built rather rapidly in 6 years when it was deregulated, when it was not a regulated industry, right? So 6 years, that kind of penetration, that penetrated faster than any other disruptive technology in history. Okay, so the FCC had to go, oh, but that's not fast enough, in order to justify, okay, so now this triggers this new meaning, this new interpretation that we have of 706. So that, yeah, gosh, if the court's having to get into the weeds like that, I think maybe the commission actually might be winning, because all of a sudden it'll be granting it legal authority, but say maybe you didn't consider the evidence correctly, it was arbitrary and capricious. I hope it doesn't have to go there, but it's an excellent point in that 6 years from 15% to 95% is inadequate, and therefore then the next step beyond that, by the way, would be we're not going to look at the language of 706 saying we're going to remove barriers. We're going to create more rules, and that those new rules are actually going to spur broadband deployment. That's all backwards.
May I, just on this point, one very important point that did not come up today is that if 706 is a grant of authority, what it clearly requires is that the commission bears a factual burden, not merely of showing that the regulations it's proposing will in some respects enhance investment, but that on the whole, the net effect will be to enhance investment and competition. And if there's one major failing in the commission's analysis, it's that they've built up this set of arguments on one side of the aisle, saying there's the triple bank shot theory by which we're going to promote use of the internet, and that will in turn promote investment. And they said essentially nothing, really, on the other side as to what the countervailing effects, the direct effects are on ISPs. So it's got to be a net analysis.
Markham, let me ask you to respond, and also to take account of a question from Judge Tatel at the argument, which was that if our conception of broadband changes over time, such that the older start point that the commissioner mentioned is no longer adequate for many purposes, does it become appropriate for the commission to say, well, in terms of modern broadband capabilities, that the deployment is no longer reasonable at time because we've upped the bar?
Well, I think that if the court moves into the questions of whether the FCC has justified in the record its factual findings that there is that these rules would promote competition or lead to remove barriers to infrastructure investment, then the FCC is certainly on their strongest ground because of the deference they get, which is why I think Verizon in their pleadings spent a great deal of time in going after whether the FCC has the authority or not. I think, certainly that's why they are an expert agency and they are able to make these type of determinations. I think they'll get a lot of deference on those. It's hard for me as a policy matter to second guess whether they were right in making those decisions or not, but those were the findings that they made factually in their reports.
Can I make one closing
please.
comment? And you guys can keep going if you need to. Unfortunately, I'm overbooked today, so I apologize, Berin. But gating question. I always like to go back to the beginning of the flow chart. If indeed the FCC had the authority to do what it did, why did it try to get authority from Congress in the 07-08 timeframe, but did not pass Congress? Why did Congress feel as if it needed to do that? Thank you for putting this together, and there'll be lots more to talk about on this, I'm sure.
Thanks very much. Well, why don't we take any more questions from the audience? We've given you very little chance to ask them. No other questions. questions? Berin, do we have time for closing thoughts?
We have plenty of time. Okay. We're set to go till 1:45. Okay. There's a lot more I think the panel wants to discuss.
Well, why don't we take this question from the front?
Things like that. Oh, okay. So I wanted to ask you what each of you think will be the ultimate effect of, let's say, if the rules are struck down or if they're allowed to go forward. What does that mean for a Verizon? What does that mean for, internet services? Give me the business end of this, if you would, please.
Terrific. Sherwin, why don't you start with that one?
Sure. Well, I think if the rules are upheld, I don't think that changes a lot. I mean, Verizon was the only one to really challenge these rules. AT&T, the cable companies, they didn't challenge them. People are investing and building out on their networks already. I don't think that it becomes a real game changer. If they are struck down, I think we are seeing at the edges of things a tendency for even though Verizon says to the public that we're not really interested in starting to charge you an extra Netflix bill or an extra this or that. We're starting to see providers trying to find ways of charging differential prices depending upon provider as well. I think we might start seeing a lot more of that, and we might start seeing a lot of more favored services.
Markham, if the court strikes down the rules, what do you think the prospects are for the Commission re-engaging in the debate about reclassification of broadband under Title II and/or Congress stepping in to provide what the court said was the missing authority?
Excuse me, thanks, Matt. If the court strikes down the rules, it will create a vacuum in terms of regulation of broadband internet. Think really expect you'd see authority, and we're also P say that the FTC doesn't come briefly. And it is with mine. Some of that. I think there is the vacuum will need to be filled, and in terms of what can happen, the FCC certainly has the ability to continue with the the reclassification docket.
And I suspect you're going to tell us that the vacuum doesn't need to be filled, and that reclassification is not so easy as Markham says. But
And Matt Brill is retiring from Latham & Watkins to join TechFreedom. In case you didn't know, he's just going to take over my job. Well, so there is no vacuum. The Federal Trade Commission and the Department of Justice have general jurisdiction over the entire economy, except in the case of the FTC, where a company is regulated as a common carrier by another agency. As the second to last Republican chairman, Debbie Majoris, made very clear in her lengthy legal analysis, by something I think is shared by all commissioners at the FTC. If the FCC is not in the business of regulating net neutrality, it's not like the FTC has to be asked to jump in. Congress doesn't have to do anything. The general laws of application will apply to net neutrality concern. Verizon and Google's self-regulatory principles will be directly enforceable without any need to invoke any showing of market power or harm to consumers. We could have a conversation about how things like the Broadband Internet Technical Advisory Group can be used in a multi-stakeholder context to generate principles by which the industry could be governed that will all be enforceable by the FTC. The antitrust laws will apply, the consumer protection laws will apply, the states can enforce their laws. This idea that there's a vacuum out there is a myth. And it's a myth perpetrated in large part because the FCC is trying to have it, as Matt said today and as Judge Silverman said today in oral arguments, is trying to have it both ways. In the broad arc of communications law for the last 20 years, especially since the Cable Act, the FCC has been fixated on this idea that cable has gatekeeper or bottleneck power. And in 1995, when the Turner decision was decided, that may have been true. It is no longer the case. And now what the FCC is trying to do is to hold on to that basic justification for regulation without actually having to go through any of the rigor of showing that there is market power. That's precisely what Judge Silverman was getting at today. And that's the question that really I think all of this comes down to. The FTC is perfectly capable of protecting consumers where there is an abuse of market power, but also where there are unfair practices. The FTC's unfairness doctrine, which I have some great concerns about being overused, is incredibly broad. It does not require any showing of market power. It requires merely that there be an injury to consumers without countervailing benefit that is not reasonably avoidable by consumers themselves. The FTC has plenary authority to punish deception. All of those things can be dealt with by the FTC. I want to say one more thing about this idea that somehow there's no problem here because only Verizon was willing to stand up against the FCC. The fact of the matter is the FCC has operated in such a way routinely over the years to pressure companies to do things, to threaten to shut down nonprofit organizations that criticize them, that it's hardly surprising that if one company actually is willing to stand up on behalf of an industry to challenge an agency in court, that everyone else is going to run for cover. And it's not because they don't have a legal argument or because they aren't concerned about something. It's because the FCC brings pressure to bear through very dastardly extra-legal tactics, like saying to companies, oh, you know that Spectrum deal that you have? We might go easier on you if you drop your lawsuit against us. That's the reality of what we actually deal with. The FCC is already playing well outside the rule of law. And I'll just say maybe one final thing, both in that, and then I'll stop, in that respect and also on the First Amendment status. One of the difficulties that you heard in oral arguments today that certainly tied up Verizon's counsel is that on the one hand, they want to stand on their First Amendment rights. It's well accepted under First Amendment doctrine that the mere fact that you're not exercising editorial discretion does not mean you waive it. So they want to say, we want to be recognized as fully protected speakers. But as a business matter, and this should allay some of the concerns that are raised here, Verizon isn't just waiting to hit the block button. None of the ISPs out there are going to shut down the internet in the way that the 30-minute episode of The Office that was produced by Public Knowledge today suggests. Right? What they're really trying to do is innovate so that Sherwin said nothing will change if the order stands in place. Well, that may literally be true because what the order is trying to do is preserve the status quo. This is all about whether we're going to have a dynamic, flexible marketplace in the future where when some video provider comes around and starts offering 3D streaming that's incredibly bandwidth intensive, there's a way to structure that arrangement, just as ESPN proposed in the wireless context, so that consumers can get the content they want when they want it in an internet that looks different from today.
Let me ask you, broadband providers for years have been arguing that FTC enforcement of Section 5 of the FTC Act that has broad jurisdiction over unfair acts ought to be sufficient to address any consumer, any competitive practices. Can you give us in a nutshell the view from public knowledge of why this issue has to involve rules from the Federal Communications Commission and why general FTC oversight is not sufficient?
Sure. I mean, look, the FCC is the expert agency on this issue. There are people keep talking about how technical and how complicated these issues are. They have that experience and that expertise. Beyond that, I think, Berin's comment about his discomfort with the FTC's breadth of authority as well, I think points to another reason why it's important that the expert agency on this have authority over it. Because the ability of the FTC to enforce the letter of its rules and its authority, and the ability for DOJ, as I said, to use traditional antitrust is severely limited. And I'm fairly confident that if we were in a universe where these rules didn't exist, where the FCC didn't have authority, that Berin wouldn't be arguing for the FTC or the DOJ to step in.
I'm arguing for the the application of general rules like antitrust and consumer protection in a sensible way. I wouldn't necessarily agree with every application that's brought to bear, but I will say that the role that antitrust plays is primarily not in litigation. It's by creating incentives from ex ante, so that, for example, in the concern about data tiers and so-called data caps, one of the reasons why we're dealing with a tier and not a cap, and why it is at 300 gigabytes and not 50 gigabytes, is precisely because we have the antitrust laws in place to discourage companies like Comcast or Time Warner.
You're saying it's the antitrust laws that are creating the difference between, what is the difference between a tier and a cap? A tier is when you get charged more if you go over, and a cap is when they, shut off your internet if you go over?
Yeah, a cap is you cannot use more, and a tier is you can always pay more for more service.
So it's not the power of the market, it's purely antitrust that keeps,
I think it's both.
ISPs from doing that?
I think it's both.
It seems like that distinction is an odd one to be making, because I don't understand why any company would want to cut off its own customers rather than extract a larger fee from them.
Brad, did you want to jump into this?
It gets back to what would happen. I mean, there's a whole possible series of economic consequences on either side, and you can argue whether they're at the margins or whether they're really significant. I mean, I don't expect the court to address the First Amendment issue, but that, as you probably could tell, was the one thing I would get impassioned about. And finish my point earlier, I think, as an advocate, you want to win your case, and if that means I have to say the First Amendment doesn't apply because that helps me win my case, I'm going to say that. But as a matter of public policy, to say that economic considerations should be the most important thing and fundamental Bill of Rights issues should just not apply, to me is just putting the cart before the horse. And the idea that Verizon can't be serious with their argument strikes me as disingenuous at best. And I use the NSA example not because it's directly on point, but these Bill of Rights issues exist there for a reason. And going to Berin's point, as soon as private companies don't have the option of raising constitutional rights and responses to requests from the government, and us consumers don't know about it, what do you have left? Because the economic issues aren't going to affect that interaction one way or the other. So saying it doesn't apply, to me, is giving away internet freedom in a far worse way than anything that can happen to us economically. And then the point I would then back that up with is, those who say it doesn't apply conflate it with, if it applies, we can't do net neutrality. That may be true, but at the end of the day, the court, when they apply issues like the First Amendment, decides what level of scrutiny applies, and then they look at the regulations at issue, apply that level of scrutiny, and decide whether they can survive or not. In other words, saying the First Amendment applies is not the same as deciding the case. But saying it doesn't apply is the same as saying we've lost those protections going forward.
Well, I will venture a prediction, since I'm not appearing in this case. I think it's clear to me from watching the argument that the court is not going to opine on the First Amendment questions. I think the court is highly likely to vacate the rules on the ground that they constitute an impermissible form of common carrier regulation. It seemed to me that Judge Silberman and Judge Tatel were firmly convinced of that view. To me, the one open question is Judge Tatel really seemed to entertain the notion that he could vacate the non-discrimination requirements while leaving intact some form of no blocking rule. It seemed that Judge Silberman really struggled with that concept and thought a no blocking rule itself had to be a form of common carrier regulation, whereas Judge Tatel, I think, really drawing from his data roaming opinion in Szoka, saw an important distinction and really seemed to be, I think, grappling with whether there was a way to find that severable, and seemed to hint that they serve different purposes. I wonder if the best outcome for many of the companies would be some sort of split the baby decision that keeps intact a no blocking rule that Verizon's counsel said it had no problem with. It said it had no desire to block. I think the industry position has always been clear that the restrictions on two-sided markets on pay for priority are what concern them the most. So interestingly, a vacature of everything might be more damaging from an industry perspective because it would invite inevitable debates back before the commission about Title II, back before the Hill. So we'll have to see how far the court goes. But
I will just say on that point, I think that's clearly he was trying to apply his data roaming decision analysis there. I think he certainly saw that there was room. to let the no blocking and transparency rules stand, but that's a separate inquiry from the separability question. And I think, you could come to that conclusion intellectually as a matter of how common carriage is analyzed, and still decide that the rules are not separable, and therefore that the entire order must be struck down. But if they do split the baby, and we wind up with the court simply writing out the non-discrimination rules, we will have non-discrimination rules in place, and there'll be antitrust rules. And I'm perfectly comfortable with antitrust and consumer protection law governing that marketplace.
Great. Well, I think that takes us to the end of our allotted time, and thank you all for coming.